You know, sometimes just one single event can come along and completely change everything. It can literally rewrite the rule book. Today, we're going to dive into the story of one of those events, a story about a reservoir, a hidden danger, and the flooded mine that changed the law forever. Okay, so let's set the scene. We're going back to the 1860s, right into the heart of England's Industrial Revolution. Think steam, steel, huge ambition. But with all that incredible progress came new dangers, ones that nobody had really thought about before. And here's where we meet our first character, a mill owner named Mr. Rylands. Now, like any smart business owner back then, he needed power for his mill, and that meant water. So he had a pretty straightforward idea. He was going to build a huge reservoir on his land. Simple enough, right? Well, here's the twist. See, underneath his land, totally hidden from sight, was this whole network of old, forgotten mine shafts. Just sitting there, a ghost of old industry, just waiting to cause a problem. And this brings us to the central question we're going to unpack, a question that totally stumped the courts. When a disaster happens, but no one was actually careless or negligent, who pays? Whose fault is it when, technically, no one is really to blame? So, that's the setup for this famous case, Rylands versus Fletcher, all the way back in 1868. And what started out as a pretty simple fight between two neighbors, well, it ended up creating a whole new branch of law. Okay, so let's break down exactly what went wrong. Rylands hired contractors who he thought were competent pros. While they were digging, they came across these old mine shafts. But, and this is the crucial part, they didn't think it was a big deal. They just figured they were blocked up. They were wrong. Those shafts were connected directly to the working coal mine of his neighbor, a Mr. Fletcher. The second Rylands filled up his brand new reservoir, it was game over. Water exploded through those weak points, surged into Fletcher's mine, and caused an absolute catastrophe. And here's the kicker, right? Rylands himself hadn't been careless. He'd done nothing wrong. So the courts had this massive problem on their hands. Rylands wasn't negligent, but Fletcher's business was destroyed. Their solution was pretty radical. They didn't just tweak an old rule. They created a brand new one. And we call it strict liability. So what is strict liability? Well, it's a pretty wild concept. It basically means you can be on the hook for damages even if you weren't careless, even if you did everything by the book. The focus shifts away from fault and onto the simple fact that your risky activity went sideways. And I love this quote from the original judgment by Justice Blackburn. He said that if you bring something dangerous onto your land, you keep it there at your peril. It's so direct. It means if that thing gets out and wreaks havoc, you are responsible. End of story. So over the years, this big idea got boiled down into a kind of four-part test. If you want to make a claim using this rule, you've got to prove these four things. First, that it was a non-natural use of land. Second, that the thing was likely to cause trouble if it got out. Third, that it did in fact escape. And fourth, that it caused damage you could have foreseen. And right away, we hit a snag. That very first ingredient, non-natural use, has been, let's just say, a bit of a legal minefield. What on earth does non-natural actually mean? Well, that definition has been a moving target for over 150 years. Okay, check this out. Here are two cases that show just how much this idea has changed. Back in 1969, a court decided that storing metal foil in a factory was a natural use of the land. Pretty standard stuff for a factory, right? But then, jump to 1994, and a court said storing huge quantities of chemicals was non-natural. Why the change? Because it was seen as an activity that carried an exceptional risk. The context and our perception of danger had totally shifted.
And to make things even clearer, let's look at something more modern. In 2003, a huge water pipe that supplied a block of apartments burst. The court said, nope, that's a natural use of land. Why? Well, because having big pipes to supply water to apartments is just normal. It's an ordinary part of life and doesn't carry some kind of exceptional risk like stockpiling industrial chemicals does. So you can see the rule is actually getting narrower.
Okay, so right now you're probably thinking, wow, this rule sounds super harsh. And you'd be right, but the law always creates loopholes or, defenses. There are a few key ways you can get out of a strict liability claim. And here are the big five. You can claim it was an act of God, and we're talking a truly exceptional, once-in-a-century storm, not just a bit of bad weather. Or you could say it was the act of a stranger, meaning some third party you have no control over caused it. There's also consent, where the claimant knew the risk and was okay with it. Statutory authority, where a law allowed you to do it. Or, my personal favorite, that the claimant's own actions were the real problem.
Okay, another one of those simple words that gets really complicated in law is escape. It seems obvious, right? But what does it actually mean for something to escape in this context? So the basic idea is this. The dangerous thing has to physically move from the defendant's land to somewhere outside their control. There was this perfect case for this, Reed v. Lyons. A munitions inspector was injured by an explosion inside the factory she was inspecting. Her claim? It failed. Why? Because even though it was a terrible accident, the explosion happened inside the factory. Nothing dangerous actually crossed the property line and escaped. The dangerous stayed put.
All right, so this all brings us to the million-dollar question. We've been talking about a case from the Victorian era. Does this rule, born in the age of steam engines, have any place in our world today?
Well, a quick look here tells you pretty much everything you need to know. The short answer is not really. Claims using this rule are incredibly rare today. They've been completely overshadowed by the undisputed heavyweight champion of this area of law, negligence. And negligence is all about proving somebody was at fault.
So why the huge shift? Well, it's really about a fundamental change in how we think about fairness. As a society, we've really leaned into the idea that you should only be held responsible if you were actually careless. This old idea of liability without any blame just doesn't sit right with us anymore. On top of that Cambridge water case we mentioned added another hurdle. The type of damage has to be foreseeable, which pushes the rule even closer to negligence and makes it way harder to prove.
But, hang on. Just when you think it's down for the count, could this old rule be gearing up for a comeback? There's a really interesting debate happening now about whether it could be the perfect weapon for a very modern problem, protecting the environment. And the arguments on both sides are fascinating. On one hand, the people who support using it have a powerful point. Imagine holding a company strictly liable for a chemical spill, no matter how many safety rules they followed. It could be a massive deterrent. But on the other side, critics point out that we already have a ton of specific environmental laws. They argue it's unfair to punish a company that might have done everything right using a rule that doesn't care about fault.
So where does that leave us? What's the bottom line? The rule from that flooded mine is still with us. It survived, but its role has totally changed. Think of it less like an everyday hammer and more like a very specific specialist tool you only pull out for the most exceptional, high-risk situations.
And that leaves us with a really big question to chew on, one that gets to the very heart of this whole debate. When disaster strikes, where should the law put the burden? On the person who knowingly took an exceptional risk for their own benefit, or only on the person who actually made a mistake? The way we answer that continues to shape our laws and our world.